Uh, Hello to everybody. My name is Matthias Kovac, and I am owner of this firm, Lexiaco, Legal Business, Financial and Tax Service from Slovenia. Also, I work as a public procurement advisor at the National Institute for Public Health in Ljubljana. And I would like to present my paper at this international conference in London, named Conditions for Access to the Public Procurement Market for Tenders from Third Countries. So first, I would like to introduce this paper, and then we will go by sector from explanation to the end. The globalization of trade and the expansion of international supply chains have increased the participation of third country tenders in public procurement procedures. However, this openness has also raised some concerns regarding reciprocity, unfair competitions, state subsidies, strategic dependencies, and unequal access to foreign procurement markets. As a result, the European Union and other states have gradually introduced legal and policy instruments designed to regulate access conditions for tenders from the third country. The issue of the third country access to the public procurement markets is therefore situated at the intersections of international trade law, EU internal market law, competition policy, and national security considerations. The purpose of regulation of European Union of the European Parliament is to improve reciprocity of access to public procurement markets between the European Union and third countries, in particular where tenders from third countries do not have comparable access to public procurement in the European Union or vice versa. The regulation lays down rules and procedures to ensure the exercise of the union rights under international trade agreements concluded by the union. No such rules and procedures exist to the treatment of economic operators, goods, and services not covered by such international agreements. The international market access obligations undertaken by the Union towards third countries in the field of public procurement and concessions require, inter alia, equal treatment of economic operators from those in third countries. Now here we have the table, difference between rejection under the Procurement Act and directive from European Union and refusal under IPI regulations for third countries. So we have criterion here, legal basis, reason, procedure, effects, proving, and client flexibility. Now, rejection under Procurement Act is going to be that the country of origin is not a member of the GPA system and does not have an agreement with the European Union. So we have no access rights. Also, the procedure, the contracting authority determines the country status and may reject the offer. The tender may be completely excluded, and the bidder must demonstrate that the country has the right of access. The contracting authority may decide on exclusion if there is no legal basis for access. By the refusal under the IPI regulation, the country is subject to EU restriction due to lack of the reciprocity in public procurement. So the EC adopts an official implementing decision. The contracting authority must comply with it. Restriction can be different here. In rejection is exclusion. In refusal under IPI regulation can be complete exclusion or mandatory discount estimated. The contracting authority refers to the EC implementing decision by proving, and the contracting authority has no discretion. It must follow the rules set out in the AC decision. That is criterion for rejection or refusal the third parties or the third country in public procurement system. Now we will determine the origin of substance. The origin of economic operator is considered to be, in the case of natural persons, the country of which the person is a citizen or in which that person can be right to permanent residence or permanent establishment. In the case of a legal entity, the country under whose law the legal entity is incorporated or otherwise organized, and in whose territory the legal entity carries out its essential business activities. So if the legal person does not carry out substantial business activities in the territory of the country in which it is incorporated or otherwise organized, the origin of the legal person is the origin of the person or persons who are able to exercise directly or indirectly a dominant influence over the legal person by virtue or their ownership of that legal persons, their financial participations, or it on the rules governing by this legal person. Person have a dominant influence over the legal entity in the following cases. If they directly or indirectly own the majority of the subscribed capital of the legal entity, if they directly or indirectly control a majority of the votes, or if they can directly or indirectly appoint more than half of the members of the administrative management or supervisory body of these legal persons. Now we have here checklist for subscribers. What we have to control, what we have to be careful by when we have a bidder from third countries. First, we have to check if IPI mechanism is used. First, we have to put the question, is the order value above the threshold? So the threshold is construction or concessions must be higher than 15 million euros, excluding VAT. Goods and services must be higher than 5 million euros, excluding VAT or VAT. The second question is, has the Commission issued a decision on an IPI measure for a specific third country and sector? These two questions can be checked in the official journey of the EU or in the notice of the EC Ministry of Finance website. Then we have to go to the section preparation of tender documentations. So here we have to control, or here we have to see, is there include in the call of reference to the IPI measure and the legal basis. So if we have this part in regulation. Also, we have to control that this indicate that bids from the country in question are excluded or treated with the bid price adjustment. So if we can exclude such bid, or we treated this bid as a bid price adjustment. It specifies the requirement for the proof of origin of goods and services and the share of subcontractors. This is the third matter that we have to check and we have to control in this section of preparation of tender documentations. Then we have to check the offers. So check the provider's headquarters, verify the origin of goods or services, and check the proportion of subcontractors. This is very important in the next step. If the measure applies, eliminate the offer or adjust the evaluation. But next section for checklist for subscriber is after placing an order. So when we place an order and we also have a bidder, most successfully bidder, we have to include clauses in the contract about limiting subcontracting to the maximum stage of 50% for the country in question. Also, we have to limiting goods and services from the country in question to a maximum of 50% of the value. Beside of these limitations in the contract, we have to include a contractual penalty clause. This penalty can be 10 or 30% of the contract value in the event of a breach. When we have situation during the performance of the contract, we must regularly check the origin of goods and services, check the subcontractors and their shares, and if you find violations, enforce a contractual penalty. Also, the Commission may, on its own initiative or following a substantiated complaint from the interest party, from the union, or a substantiated complaint from a member states, initiate an investigation into an alleged measure or practice of a third country by publishing a notice in the official journal of the European Union. Now we have another section. This section is International Procurement Instrument of the Regulation, IPI measurement. The decision as to whether the adoption of IPI measure in the Union interest must be based on an assessment of all the various interests taken as a whole, including the interests of Union economic operators. The IPI measure shall apply only to the public procurement procedures whose estimate value is about the threshold set by the Commission. This estimate value should be, we said in a previous slide, 15 million euros, excluding VAT, or more for construction and concessions, and 5 million euros excluding VAT for more for goods and services. The Commission may taking into account also the scope restrict the access of economic operators, goods or services from a third country to public procurement procedures by requiring contracting authorities or contracting entities to introduce an adjustment in the evaluation or exclude tender submitted by the economic operators originating from the third country. Now we have a case decision to exclude the offer. How we prepare this decision to exclude the offer? We have four parts. First is the origin of the provider of goods. The provider is established in the specific country, which is considered as a third country within the meaning of the EU law. The goods and services offered by the provider originate from the specific country. When we ended this first section of the decision, then we prepare the second section. This second section is about European Commission Acts, IPI measure. The European Commission adopted implementing decisions imposing access restriction to economic operators and or goods from specific country in accordance with the regulation of European Union. The decision stipulates that economic operators from the country may not participate in public procurement procedures in certain areas, or that their bids will not be taken into account in the evaluation. The third part of the decision is legal assessment. In accordance with the article of regulation and the European Commission implementing decision, the contracting authority is not entitled to accept the tender from an economic operator from that specific country. And the last part of decision is client decision. In view of the above mentioned sectors, the contracting authority finds that the tender of the tenderer, the name of the tenderer, is not compliant with the EU restrictions. The tender is therefore excluded from the sum procedure. Now, what is the obligations of the successful tender? Contracting authorities or contracting entities shall also impose the following obligations or on successful tenders in the procurement documents, so that they will not subcontract more than 50% of the total value of the contract to economic operators from a third country, subject to the IPI measure. To ensure to supply contracts that during the contract period, the goods supplied or service provided originating in the third country is subject to an IPI measure, do not represent more than 50% of the total value of the contract. Also, they have to provide the contracting authority or contracting entity at their request at the latest at the end of the contract performance with the appropriate evidence in accordance with the point A and B. Also, they have to pay the proportional costs in the event of failure to comply with the obligations referred to in point A and B, which amount to 10% or to 30% of the total value of the same contract. But contract authorities may not exceptionally decide not to apply the IPI measures in a public procurement procedure where we get only offers from economic operators from a third country subject to the IPI measures, and these offers meet the tender conditions. Or decision not to apply the IPI measure is justified by imperative reasons of public interest, such as public health or environmental protection. Now we have the case of IPI measures in practice for Slovenian contracting authorities. First is direct validity in Slovenia. The IPI is an EU regulation, therefore it is directly applicable and does not require special implementation in the Public Procurement Act. Slovenian contracting authorities must comply with the rules just like the other public procurement rules. When to use thresholds, construction and concession, more than 15 million euros excluding VAT or VAT. And also goods and services more than 5 million euros excluding VAT. Conditions which we have to consider: the measures applies only if adopted by the European Commission for a specific third country or a specific sector. Now we have another section. This is forms of measures. When the Commission finds that the third country discriminates against the European EU companies, it can impose exclusion of tender from this country or bid correction. Then we have another section, obligation of the client. The client must check origin of the goods, the country of the provider of the or provider's headquarters, and the share of subcontractors from the country to which the measure applies. And last section is limitation for successful bidders. Limitation of successful bidders is a maximum of 50% 50% of the contract value and may be performed by the subcontractors from that third country, and a maximum of 50% of the value of the goods or services which may originate from this third country. Violation entails also contractual penalties. We said in our previous slide, 10 to 30% of the order value. Now, conclusion. One of the most important conclusion is that the European Union have the most open public procurement markets in the world. The WTO government procurement agreement remains the cornerstone of the international procurement markets. At the same time, the important legal and policy development has been the clarification of that third country operators do not automatically possess the same rights as EU companies. Another major conclusion concerns the growing importance of the reciprocity in internal procurement policy. The IPI demonstrates that the public procurement is increasingly viewed not only as an administrative activity, but also as a strategic, economic, and trade policy tool. From the perspective of a contracting authority, we have to get a great awareness and expertise. From economic operators, the changing landscape presents both opportunities and challenge. In this major conclusion, the conditions governing access of third countries to the EU policy procurement market reflects a delicate balance between openness, reciprocity, competition, and strategic interests. That's ending of my presentation. If you have any question, you can put the question into my email and I will answer about this thematic or about matters of public procurement in European Union or public procurement in Republic of Slovenia. So thank you for your attention and see you soon in next conference. Thank you.